SJC-13229, Joseph O'Leary, v. Public Employee Retirement Administration Commission.
Okay, Attorney Hill.
May it please the court. My name is Ken Hill. I'm representing the Public Employee Retirement Administration Commission, or PERAC, as it's easier known as. PERAC is the agency charged with the administration of the 104 retirement systems throughout the Commonwealth, pursuant to Mass General Law, Chapter 32. This is a matter before you of statutory interpretation. The statute in question was passed by Chapter 21 of the Acts of 2009. Changes were made to definitions in Chapter 32, Section 1, specifically the definitions of regular compensation and wages. The underlying question before the court is whether payments made in lieu of taking vacation time constitute regular compensation and can be included in determining a public employee's retirement benefit. Prior to passage of Chapter 21 of the Acts of 2009, the definition of regular compensation and wages included the phrase, other compensation in whatever form. Now, many employees use this language to monetize things like housing allowances and car allowances and clothing allowances. The legislature sought to close that loophole. The definition changed of regular compensation and wages. The list of payments excluded from wages, was included, and it included the phrase, as being excluded from wages, one-time lump sum payments for unused vacation time. It did not exclude any...
Counsel, can I ask you to address, so I see that language, the one-time lump sum payments in lieu of unused vacation, the vacation buyback, right?
Yes.
In a lump sum form.
Correct.
But the statute also was amended to say, shall not include without limitation. So there's sort of a double negative built into the statutory language. Can I ask you to address that?
Absolutely.
So it doesn't include one-time lump sum vacation buybacks, but why does that mean it doesn't include vacation buybacks over time?
Well, I would argue that there has to be a reason they included one time rather than multiple. And the without limitations aspect of it, that's a catch-all provision. I believe that when the legislature passed the Acts of 2009, they assumed in the future that employers would come up with future unknown forms of compensation. For instance, recently we've seen compensation paid out for public safety officers using Narcan in overdose situations. That was not contemplated by the legislature back in 2009. Multiple payments for unused vacation days was contemplated by the legislature at that time. And I think they willfully excluded that or did not include that.
Well, Counsel, can I press you on that? Because you're arguing the negative implication, right? And just this week, we cautioned against that, of looking at statutory language and using the maximum negative implication, which is what you're doing. Because we said in that decision just this Monday that the reason why you have to look at that cautiously is because you have to look at the overall statutory purpose. And you just said what it was. People were bumping up their regular compensation with all types of things to increase their retirement benefit. So if the legislature with the change in 2009 was trying to circumscribe that, why wouldn't it make sense that even though they said just the one-time lump sum payment, that it also wouldn't include the regular interval payments, because it does the exact same thing you said that the legislature tried to obviate by having people just bump up their regular pay to bump up their retirement benefit?
Well, I think that it has to do with the one-time aspect of it, is because at the end of someone's career, they're paid out in a one-time lump sum, all of their accrued vacation time. And that is an enormous benefit for some people. And I think they wanted to be specific that that is not included in someone's retirement calculation. I would also argue that The without limitations needs to be read in conjunction with the whole of the statute, which includes the phrase, "and all payments other than payment received by an individual from his employing unit for services rendered for such employing unit." I would argue that the vacation buyback provision is a service rendered. It's a service both in the macro and in the micro. As the macro, the employer is reaping a benefit, okay, by someone such as Mr. O'Leary working 2 weeks instead of taking vacation time. The employer does not have to hire someone new and train them to take his spot for those 2 weeks. Or, in the alternative to that, pay someone overtime at time and a half to take his time. In the micro, I would argue that it's a service for the employer because he is there. He's clocking in, he's working his shift. He's performing duties, which is a service for his employer.
Well, going to the statutory interpretation, help me out with this, though. We have a change in the statute for the definition of regular compensation, and the change includes shall be compensation received exclusively as wages. Help me out, because when I hear vacation buyback, that doesn't strike me as wages.
It is wages, okay?
Why?
Because in the situation of Mr. O'Leary, it was broken down. He was not given a check, okay, for those 2 weeks, okay? It was worked into his 26 biweekly paychecks, okay? And it became part of his wages. It was essentially a raise.
A raise he gave himself.
No, his employer gave it. It was collectively bargained for. It was a benefit.
Well, you mentioned collectively bargained for. Can you help me understand one? I guess might be more appropriate for Mr. O'Leary's counsel, but the collective bargaining agreement that he signed and was subject to accepted this out of his regular compensation, right?
It did.
So he's not getting anything more than he bargained for.
You can bargain for anything, essentially. Chapter 150E does not trump Chapter 32, however. Okay? We frequently see situations where it's the obverse of that, where CBAs claim this will be deemed, overtime pay will be deemed regular compensation. And we say, no. It's not under Chapter 32, so it is not regular compensation.
Well, can I press you a little bit more then? So one of the things that that seemingly you were looking to was the memo,
Yes, sir.
right? And the memo sets out a two-part test, right? For in instances where you could define this as regular compensation. The first one is the part that I'm struggling with, where the first part of the test talks about payments may be deemed other base compensation if the payment is of limited duration or if the payments lack predictability. When it says lack predictability, are they talking about the interval of the payment or the payment itself, the amount of the payment itself?
I think they're talking about both, but I would argue that because if you follow our memo, as I'm sure you have looked at, we're telling the boards, these are things you need to assess, okay? So the retirement board needs to look and see, was this regular and recurrent? Was this predictable? And it's arguable, again, the retirement board's supposed to do the analysis, it's arguable that Mr. O'Leary's case, because he did it every year he was eligible for 7 years prior to his retirement, it was regular and recurring and predictable.
Even if he chose not to do so. I mean, you're arguing that it's predictability because he chose to do so, but there may have been a year where he chose not to do so. So wouldn't that be something that the board could factor in? And so isn't that a reasonable interpretation that they haven't met the first step?
It's very possible. Again, the retirement board is the entity supposed to do that analysis, though. And here, the Lexington Retirement Board did not do that analysis.
Mm-hmm.
Okay, any other questions? Thank you very much.
Thank you very much.
Okay, Attorney Becker.
May it please the court, John Becker representing retired Lexington Police Captain Joseph O'Leary. I wanted to address some of the issues that the court has already brought up. I think the question Justice Lowy had about wages, I think it's important to look at it this way. When a police officer or when an employee is earning their base salary does not include vacation leave pay, sick leave pay. These are all things that are in addition to base salary. That's why they're using the term other base compensation. One of the reasons also things like educational incentive, longevity pay, night shift
They're
differential.
not taxed either, are they?
What's that?
It's not taxed either. By income tax, the vacation pay and the,
No, it is. It's included the way that other base pay is.
okay.
Here's the thing. If Mr. O'Leary took those 2 weeks every year of vacation, he went on vacation, whatever he did, Disney World, doesn't matter, he gets the 2 weeks of vacation pay, correct? That 2 weeks of vacation pay, even though he's not working, so he's not technically performing a service, it's included in his regular compensation. It's included in that 2 week period is included in his creditable service for purposes of calculating how much he's worked. Same thing if he was out sick for a couple of weeks, et cetera. Workers' compensation is a different case, as we see in Vernava, but that's specifically because of statutory exclusion. Why is the pay that he received for those 2 weeks any different if he receives it during the 2 weeks he's on vacation or if he receives it for not taking the vacation? It's still the same money.
But it's extra. Let's just say he just has 2 weeks of paid vacation per week, and we say a year's 52 weeks. And in your calculation, he's being paid for 54, not 52.
I disagree, Your Honor. I don't think he's being paid for 54. I think he's being paid for 52, and he's getting a raise for 2 of those weeks because he's got this, it would be similar for, let's say he, halfway through the year, he bid for the night shift. All of a sudden, his pay goes up because now he's getting night shift differential. So here, he's getting vacation buyback as a benefit for these 2 weeks. I don't think he's working, he's still, the difference is the salary augmentation plans and things that they're concerned about in amending the statute, they have more to do with things like, in your last 3 years, you get a 20% raise. It's obvious that that's an end run around the predictability that's necessary to run a retirement system, right? But this case, you have a predictable, and it's predictable, and I think Your Honor's question is very important, that it's predictable in hindsight. If he had taken a week off, he had taken a year off and hadn't done it, the retirement board should knock him right out, and that's what Parek's memo says. Parek's memo says you can't opt in, opt out, opt in, opt out, then you're losing predictability. So it's and that's one of the reasons why they couldn't put vacation buyback in the statutory, in the CMR, 840 CMR 1503, because it wasn't like longevity or educational incentive in the sense that everyone who gets educational incentive or longevity is going to be included. But not everyone who takes vacation buyback is going to be included because you have to meet the standard of predictability, regular and recurring. And that's what Parek, I think, reasonably did in its memo. It set out certain standards to say these are the ways in which we're going to find that it's a regular and recurring and predictable. They're also finding that it's for services rendered, and I think to follow up on what my brother said, that the statute, the without limitation, has to be read in context with the last part of the sentence that says, or other payments not for services rendered. Otherwise, without limitation could include night shift differential, educational incentive, longevity, things that we already know that Parek has reasonably, and nobody's challenging that Parek is including in regular compensation. So I think that those are important points. I just wanted to use, I have a couple of minutes left, I wanted to use this opportunity to talk about the prospective and retroactive nature of the matter. The amicus brief folks aren't able to argue, and I think it's important to look at their reasons as to why this should be prospective only. I think this is a different case than Vernava. I think it's a different case than the Worcester Retirement Board decision that came out in February. You have a very serious situation here where this has been something that retirement boards have been doing since at least 2000. There was a 2000 memo from PARAC that there are thousands of retirees out there who are getting this as part of their benefits, who made decisions based on this. And this is one of the issues that comes up in the case of cited by one of the amici, that it impacts people's behavior. And one of the bases for going for using the exception to the general rule, that general rule is retroactive, but I think you need to invoke the exception here because there was reliance on the existing PARAC memo, on the existing retirement board practices to include this in regular compensation. People forewent, I believe that's the word, their vacation opportunities in order to get this additional pay. You have a situation where, for all anyone knew, including the retirement boards, this was includable in retirement compensation. If it's going to be changed, and I hope you don't make that decision, obviously, but if you do, I would strongly urge you to make it prospective only. I think that this case is important because it shows that the legislature, when it was making these amendments, it was thinking not with broad brush strokes, but was thinking about the specifics. And as my brother points out, one-time lump sum payment, there's a reason why they said that. That's the one that's the big inflating factor. You know, every year, if you're getting it, a small amount every year, that's something the retirement system can handle. And the legislature recognized that. They recognized that the big, you know, when you retire, the last day you get a big check, those are the things that are going to mess with the system and affect everybody else. So thank you. If there are no other questions, I'll rest on my brief.
Okay, thank you. Attorney Parr.
Good morning, Chief Justice, Associate Justices. May it please the Court, Kim Parr for the Contributory Retirement Appeal Board. CRAB correctly concluded that the vacation buyback payments made to Mr. O'Leary did not qualify as regular compensation under General Law, Chapter 32, Section 1. And I'd like to highlight 3 parts of CRAB's reasoning today that the Court has touched on a bit with the appellants. First, these payments are intrinsically extra pay. It's not a raise, it's a bonus at the employee's own election under the CBA. This is precisely the type of advantageous payments the legislature sought to exclude from the retirement calculation. For those 10 days Mr. O'Leary worked instead of taking vacation time, he was paid once for his service to the department, and then again for forfeiting his vacation time as a contractual benefit negotiated by the union. Now, that double payment is perfectly fine under the CBA, but nothing in Chapter 32 permits both payments to be counted toward the retirement benefit calculation, and that is what the appellants are asking for. This would result in the type of windfall to employees that is just not permitted by Chapter 32, and it would be at the expense of the retirement boards or the retirement systems who weren't even parties to these CBAs. Second, these payments were not regular, ordinary, non-discretionary or guaranteed as required by both the statute and the regulations. As the Court noted, Mr. O'Leary had to decide each year whether to convert his unused vacation time to pay, and if so, how many hours to convert. That decision was his own to make and not part of an established payment scheme that was paid out automatically to all similarly situated employees. Now, 2 notes on this. One, the fact that the vacation election may have been available to other employees who, like Mr. O'Leary, attained 20 years of service is immaterial. This is the lesson of Kearns, for example, where all state troopers had the option of participating in or were required to participate in a physical fitness exam, but only those who passed were able to get the bonus and the bump in their pay. Likewise, the fact that Mr. O'Leary repeatedly elected or opted into this program and that the payments were on a regular cycle is also not enough. This is the teaching of Parente, where legislators received an expense allowance on a regular cycle, but the court advised that you still must look at the other factors in the regular compensation analysis. I think the most meaningful one here is this third point, that Mr. O'Leary was not being paid for services rendered to his employer. I think Attorney Becker or Attorney Hill, I'm not sure, made the point that on a macro level, or posited that on a macro level there was some benefit to the employer in having Mr. O'Leary available for these days. I don't see how that fits into the legal analysis or the statutory definition of regular compensation. And on the micro point, again, Mr. O'Leary was paid for the services rendered when he showed up for that shift, and he received his regular base pay. These additional payments that were factored into his paychecks in the next fiscal year were, again, just a contractual benefit. It was a way in which Mr. O'Leary was able to convert his vacation time to money, essentially.
Perrick says, though, that the concerns that the legislation had, they're addressed by the prerequisites and then the 10 factors in the memo. So this is not something that can easily be done to, maybe in the last 3 years or even 5 years, perhaps, inflate your base pay for the purposes of your pension.
The idea of inflating base pay at the end of your service goes to the anti-spiking provisions of the law. And I'd respond that that's not quite what we're implicating here. Yes, the legislature wanted to stop that from happening, but it also wanted to stop ad hoc bonuses or adventitious payments that were paid to some but not other employees from being included in the retirement calculation at any point in time.
Right,
Because
but the factors, those 10 factors, they include that it's available to everybody and it has to be, for a, I can't remember the precise words, but a significant duration. And I only reference that in trying to figure out what wages means.
I understand now, Your Honor. Even if those are factors later on in the PARAC memo, it's still impossible to get through those first two factors of whether or not these payments are part of base salary or other base compensation, and whether they were for services performed for the reasons that I've just discussed. And so the PARAC memo, in Crabb's view, that the Superior Court supported, and we hope this court supports, it is an unreasonable interpretation of the statute. These vacation buyback payments can never get through those threshold showings. And I would also offer that it feels inconsistent with this court's decision in Worcester and the general application of the retirement law to place this decision in the discretion of individual boards. The better course seems to be to have one prevailing definition of regular compensation, something is or isn't counted. So right now, and apparently since the memo was issued in 2012 and an earlier one in 2000, retirement boards were able to look at different vacation buyback programs and make that decision, but that's led to inconsistency. And so to the extent the court does consider this prospective or retroactive analysis, I would offer that suggests there may not be as much hardship, or the decision may not be as novel as appellants suggest. Because at this moment in time, we know of at least 2 boards that never included vacation buyback payments as regular compensation, obviously Lexington, and one of the amici makes that statement as well. I think it was Norfolk. No, it was Leominster. And another wasn't even aware of any vacation buyback programs in their system.
You may not know this, and it may be beyond the record, and if it is, then obviously don't answer it, but when there was a statutory change in regular compensation and exclusively wages, did that impact at all boards out there as far as having the availability to be able to add your vacation time for a couple of weeks?
I'm sorry, I couldn't hear the last part of that question.
Was there a change in policy of boards as far as whether or not they would allow the vacation time to be spread out over a couple of weeks for X amount of years with an impact on the pension? Did the statutory change have a behavioral change?
I'm not aware of that. It's outside of the record. But if it did, I would suggest that shows an attempt to manipulate the system, where one-time lump sum may have been excluded, trying to find other ways to make these payments to circumvent the statute. And that's one of the reasons that CRAB disagreed with the appellant's position about the one-time lump sum exclusion. If you really do read the statute as only excluding one-time lump sum payments, it leads to this absurd result where, whether a vacation buyback payment can be counted as regular compensation depends wholly on these negotiations between an employer and employee. And the regular compensation analysis really should not turn on that. One other point I wanted to make about the 2009 amendments is that prior to 2009, regular compensation was defined to mean salary, wages, or other compensation in whatever form, for individual service, not including bonus, overtime, and severance pay for any and all unused sick leave. Once you understand that language referred to severance pay, I think the continuation of the one-time lump sum exclusion makes a little bit more sense, because that's typically how severance pay would be paid out at the end of someone's employment period.
But sick pay is different from vacation pay, right?
It is, and vacation pay was not included pre-2009. It was included post-2009. Again, with that one-time lump sum language. But importantly, the legislature presented this list of exclusions, or introduced it with the phrase "without limitation." And so it cannot fairly be read as an exhaustive list of exclusions. The better course, and what the court has done in the past, is see if some type of payment is on the list of exclusions. If it is, it's out. If it's not, you still have to consider the core definition of regular compensation. And under that core definition of regular compensation, CRAB's interpretation was both reasonable and legally correct. Vacation buyback payment should not be included. If there are no further questions, we'll rest on our brief. Thank you.
Thank you. Okay, Attorney Sacco.
Thank you. Good morning, Madam Chief Justice. May it please the court. Michael Sacco on behalf of the Lexington Retirement Board. I want to use my 5 minutes judiciously, so if there's any questions that anyone has, I'm happy to address those right off the bat. All right, hearing none, I will just reinforce some of the points that my sister made, and I think that the justices have made. I'll start with Justice George's comment about the one-time lump sum payment, that somehow 2 times having a lump sum payment is acceptable when 1 time is not. Clearly, the legislative intent was to limit the compensation upon which a retirement allowance can be based. And to the extent that this was some new change in the law, I would refer the court back, and this is cited in my brief, but to the Bassis case, which this court decided in 1981, 40 years ago. And I'm quoting, "Lump sum payments made to employees in exchange for giving up or not having used leave time are similar in some ways to overtime payments. Employees work during time when they might have taken leave. They are paid regular wages for those services and, in addition, receive extra compensation for giving up their free time or leave time. Such adventitious extra payments have long been excluded from regular compensation on the ground that they would unduly inflate regular compensation and impose justified burdens on retirement systems." That was 1981, Your Honor. And I would also point out that since PERAC's creation in 1996, its own regulation excluded any amounts paid for unused vacation time. This is not a surprise to anyone that this is excluded, and it's clear why it's excluded for the reasons that my sister mentioned. Crabb really mentioned 5 reasons why it should be excluded. It's not in the base. It clearly is not base pay. And when my brother suggests that other base compensation is in reference to this type of vacation buyback, I strongly disagree. Someone who receives base pay, you're paid $50,000 a year. If you're a police officer or a firefighter, or you hold a special degree or some certification, that you get paid every year for that. That's the other base compensation. That is your base compensation. And most importantly, these payments are not regular, they're not recurrent, and they're not ordinary. There's nothing ordinary about cashing in vacation time. Vacation is a benefit. There is no law in Massachusetts that requires an employer to give vacation time. So it is a benefit. Granted, it is treated as wages under the wage statute when you resign if you have unused vacation time, but overtime is wages as well, and that's excluded from the definition of regular compensation. It's not recurrent in Mr. O'Leary's case, and I would suggest in any of these cases, because there has to be an election. An employer can never force you to not take vacation and cash it in. You have to elect to do that. So that makes it not guaranteed, that makes it not predictable. It's certainly not ordinary, and it's not recurrent. And even if it were ordinary and recurrent and guaranteed, as the appeals court said in the Parenti case, that the analysis does not stop there. It has to be for services. There is no services that are rendered when you get a lump sum of vacation time. You have a choice as an employee to either work.
But you're working 2 more weeks than, I mean, you're at work 2 more weeks than you would otherwise. They would have to pay someone else, right? So that part, I see your first part of your argument that it's not regular compensation. I don't really understand why it's not services. Because it's not like you're getting nothing, you know, it's not like the workers' comp example where you're not working. It's you're working, and otherwise someone else would have to be paid, right? They're getting services for it.
Well, Your Honor, the services, the payment for services are working the 2 weeks, and they're electing to not work they're electing to work those 2 weeks as opposed to taking vacation time. So I don't think the services necessarily are being provided to the employer. You could extrapolate that out into, ad infinitum, into how many circumstances it's a benefit to an employee.
I get it. Before we leave, could you address the retroactivity point? Because we got a lot of people out there who are clearly
Sure.
affected by
Happy
this.
to, Your Honor. And I think this court, which was the last time I was here, addressed this in the Worcester Regional case in terms of the retroactivity. What I would suggest to you, Your Honors, is that this is not as big of an issue as my brothers make it out to be. We have 6 boards that have weighed in on this, including Lexington. The other 98 have not. I can tell you why, because I represent 53 of them, and they all agree with my analysis and that it's not regular compensation. And from a practical standpoint, they're not going to pay me to write a brief that I already wrote for Lexington. But what if you don't go back retroactive? Does that mean that it is regular compensation?
So you think it's confined to these 3 retirement boards that we're talking about, or?
I can tell you, Your Honor, in my own client base, which is 53, I'm unaware of any boards that have included unused vacation time. I can't obviously speak to the other boards, but one of the justices asked if there was a change. I think Justice Lowry asked if there was a change in 2009. There was not. It wasn't until, no one really even thought about it, because as I said, since PERAC's inception and prior to PERA, their predecessor agency, always excluded unused vacation time as regular compensation. It wasn't until the PERAC memo in 2011 that this issue was brought to the retirement board's attention, at which time, you know, I can say that I advised my clients that it wasn't regular compensation, Lexington being one of them. Lexington, Mr. O'Leary's case was one of the first that came to bear, and that's why we're here today. So I don't think the extraordinary circumstances of hardship are there. Some of the examples that were provided from the Boston Retirement Board, I think there was one person whose retirement allowance was going to go from $95,000 to $86,000. Clearly, that's a significant reduction. We have cafeteria workers who work their entire lives and make $20,000 a year. So I don't see that this is a hardship per se. Clearly, losing money in any context is a hardship. But the other point that I think Boston made in lamenting about having to give back $5 to $10 million in contributions, well, that pales in a comparison to the amount of benefits that they're going to pay out if you were to find this is regular compensation, and they wouldn't have to return that money, because there would be money that would be owed back by the members, and you would just subtract the deductions from that, and the board's going to waive the remainder of it. So there's, you know, the protection is for the retirement system, not for necessarily the individual. And I think when looking whether or not to apply this retroactively, If you don't do that, and I recognize the hardship, it will then cause all the other retirement boards to have to look back and see if they should have included it back then, because this is being a prospective rule only. So, and I think that brings us full circle to Bassus, and I'm sorry that I'm running over. I'll end with this, that this court said 40 years ago, lump sum payments for vacation are not regular compensation. The change in the statute in 2009 was not to increase what's considered regular compensation, but to restrict it. And on that note, I will end, Your Honors, unless there's any questions.